indicate that cell phone had pinged off of a tower that was relatively close to the area of the shooting within several minutes of the shooting occurring. So it tended to corroborate Mr. Griffin's, or at least someone who would have access to that phone's presence at the general time of the shooting. So that would be the reason, of course, the state would want to have the evidence admitted. For various reasons that aren't particularly important here, the trial court had excluded this evidence, essentially that the law enforcement didn't do their subpoena correctly. So proceeding into trial, that evidence had been excluded. And during Mr. Griffin's cross-examination of the lead detective, his attorney asked a simple question: is there any physical evidence that links my client to this shooting? To which, I think interestingly, the detective said no, there isn't. The state's counsel got back up, went through the redirect examination, didn't touch on the issue again. As circumstances sometimes have it, that was the final witness of that particular day. The state's attorney went home, thought better of it, wrote an email saying, I believe we do have physical evidence that links Mr. Griffin to the shooting. It's these phone records. And that question and answer opened the door to what was otherwise inadmissible evidence. The doctrine of curative admissibility is relatively well-trodden ground. Obviously, things that are excluded or are not relevant can become relevant based on the questioning if people step out of line. Our argument here, of course, is, as I've outlined in detail in my brief, is cell phone records, what the state wanted, and I think interestingly, the state never sought to have the actual handset, the device, entered as a piece of evidence. So it was not critical that the phone itself be entered. What they wanted to show was that someone who had access to that phone, which of course they were insinuating was Mr. Griffin, was near the site of the shooting, and that is evidence that's in the ether. That is data of GPS location of a cell phone. I've made the analogy in my brief, and I think it's a good one here too to just reinforce. That would be like saying that a phone call itself was physical evidence, when it clearly isn't. This is evidence that without the handset probably couldn't be obtained, but the handset itself is not the evidence. The evidence is the GPS location. And so, again, having gone home, thought better of it, and made this argument, first sending an email, then arguing it before the trial resumed the next morning, the state's counsel said that this is physical evidence, and the trial court agreed. And so at some point later on in the trial, there was some rebuttal testimony that was permitted, wherein that exact point was made, that a cell phone that's number was connected to Mr. Griffin's father's account was very close to the site of the shooting, or at least, not to get into a side argument about where cell phones can ping off of. But anyhow, all that is to say, it was corroborative of Mr. Griffin being present very close to the time of the shooting and the location. I think the trial court's error is twofold. First of all, if the court, which I'm sure will review the record.
Let me ask you.
Yes.
Prior to cell phones, and you look back at older cases, and you're talking about landlines. I know that's hard for some people in this room to believe. But
I'm certainly old enough. You're
yeah. So you would see where in sufficiency of the evidence argument, defendant made a phone call from X person's house. Therefore, that's proof that he was physically present in the house. And you can find that routinely in that argument. Are you saying that argument was misplaced then as it is misplaced now?
I mean, yes, putting aside the fact that you don't actually know who made the phone call from the house. Yeah. I mean, well, just because it connected. Let's just take a situation where it's I didn't kill the person, but I threatened them, and so that person can testify at trial. And they said he called me, and Judge Montgomery was standing next. I heard him call. He was in. That's putting me physically in the house. Well, I mean, I think in your example, the actual evidence would be there that Judge Montgomery saw you making the call. Or if you made a threat to the person on the other line, then it would be a statement against interest that would also be admissible. But I think when you're talking about if you were reviewing Bell South's records to say phone number 1 and house number 1 called phone number 2 and house number 2 at such and such a date and time, I don't think that's physical evidence. And I think that's akin to what we have here. the first argument that I was going to point to the court, and of course I made this argument also in my brief, is that I don't think the trial court actually makes that differentiation at all in her ruling. She intertwines the handset, which we would agree is physical evidence, with the records, which we're saying is not, and kind of comes up with this combined ruling, clearly, in my opinion, not appreciating the difference between the two. So I would think that is error in its own right, that the ruling should be as to the information, the evidence that is seeking to be admitted or excluded, which is not the handset at all. It is, of course, the data. So primarily, or at least from the first argument, I don't think it's clear from the record that the trial court's making that important distinction. But secondarily, and I've cited various cases in my brief that are fairly recent in the last 4 to 5 years, prior panels of this court in somewhat similar circumstances, discussing cell phones, discussing a black box in a DUI rec trial. The language, it doesn't demarcate as clearly as I'd like for my argument, but I think it's fairly clear that it says the black box is physical evidence. The data from the black box, and it would say in the same sentence, we have the physical evidence against the defendant, the black box. We also have the data from the black box. So in my mind, the panels of those courts, and it also discusses, again, cell phones and the same idea, they're differentiating between the physical evidence that is the phone or the device or the black box and the data. And so I think that's what the trial court fails to do here.
And I understand your argument, and my question is, in this case, especially since there was testimony, as I understand it, from the officer that, or whoever introduced the records, that look, that actually could have that phone call could have been made from another area, but because that tower was full, it bounced off of this tower. I mean, you almost got into it. You caught yourself a second ago.
That was my question,
there's no proof there's no real proof, and the person introducing the records says that. I can't tell you he was standing there when he made that phone call. He could have been standing somewhere else.
Well, harmlessness is another issue the state's raised, and I would say at least 2 things about that. First of all, the only evidence that Mr. Griffin did this is Ms. Corley, and I'm not sure if the court's had a chance to review the entire record yet, but to say she was inconsistent would be an understatement. So I do think this was critical information. Secondly, why would the state want this information in if it tended to prove nothing? And third, which is more anecdotal, I don't know that the state can have it both ways. I've seen many cases where they go to great lengths to show that this means this person is in this area, but in this case it doesn't really matter that much because it's just a side issue. I just don't think you can have it both ways to answer the court's argument. I think it was definitely non-harmless in this case because that was the only thing corroborating his presence other than Ms. Corley's testimony.
Well, I mean, the state could want it in to try to prove that, but if the officer admits and is cross-examined that, hey, this really doesn't mean he's there, then how much harm has it actually done to the defendant?
Well, I mean, again, if this piece of evidence is excised from the trial and the only thing that the jury has to base its verdict on is Ms. Corley's testimony, and Ms. Corley's testimony was, I'm not really sure that was actually Mr. Griffin after all, and they said, did you make statement 1, 2, and 3 to the police? Yeah, well, maybe I don't really remember making those statements. And then they said, well, in that statement you said that you saw him engage in a drug deal and then pull out a gun and shot him. Did you say that? Well, I don't really remember, and blah, blah, blah. I think, again, the dearth of evidence that was also presented by the state, any corroboration increases in importance based on that fact. Again, if there's multiple eyewitnesses, there was no statement from Mr. Griffin of any kind. There was no physical evidence, like a gun, that was linking him to the shooting. There was camera footage, but it did not pick up any part of the shooting. And, at best, taking Ms. Corley at face value, she was very distracted. She said she noticed them, and they were engaged in a drug deal, at least she believed. She called it a hand-to-hand exchange. And then she said she was, and you can see her do this because that part is on the video, she's putting her child into a car, and then all of a sudden she hears 3 shots, and she kind of looks up. So, again, even taken at face value that she maybe saw this, it's not the strongest evidence in the world. She doesn't know what happened. So, yeah, I think that I don't think it's a minor point. I think it is an important point, particularly because of the lack of evidence of the shooting, or at least putting Mr. Griffin as the shooter. And then on top of that, again, I mean, each party is going to attack the other party's witness if possible. Yes, it is true that it could have bounced off of other towers, but the whole point of doing that is to indicate that it bounced off the tower that's right next to the shooting. So, you know, again, I don't think that has successfully undercut that evidence to the point that it's not helpful to the state. I think that it is in an important way. I did want to touch on my premeditation argument, and I mentioned that just a second ago. Not only is Ms. Corley unreliable, even taking her evidence at face value, even taking the evidence that was admitted of her pretrial statement as substantive evidence, she still offers no reason for this happening. She says she saw an exchange go on, and then Mr. Griffin pulled a gun out of his waistband and fired 3 times. And that's the sum total of information, even in her pretrial statement, as to what happened. She doesn't say she knows why it happened. She assumed that it was a drug deal. But that's all the state has been able to present to the jury of any kind.
Well, the state presented that your client brought a gun, your client shot an unarmed victim, your client didn't render aid, and your client fled the scene. I mean, which case law's pretty clear, all those things go to premeditation.
I think flight by itself, I mean, if he shot him in cold blood or hot blood, would probably be a natural reaction. So I don't think flight makes much difference, to be honest. And if it's somebody that...
But it is a factor
But it is a factor
that can be
in the sense
considered for premeditation.
Well, and of course he did shoot someone who was unarmed if he was in fact the shooter. But bringing a gun, I mean, if he's going to engage in a drug deal, it's certainly not unusual for people to have guns all the time. There's no evidence that he brought the gun for the purpose of shooting this Mr. White. There's no evidence, you know, render aid, to be frank, I don't understand why that's a factor at all. If he had shot him in a second-degree murder situation...
The theory behind rendering aid is it wasn't a premeditated act. I didn't intend to shoot him. It was an accident, whatever, and so therefore I stayed and rendered aid would go against whether or not it's a premeditated crime. I mean, you may not agree with it, but it's a factor
I'm just saying
if is there.
If the court accepts this particular point that I'm making, I'm arguing that it's a second-degree murder. So I'm not saying that Mr. Griffin is blameless here if he was the shooter and these facts are the way that they're presented. But I don't see a person, maybe he said the wrong thing at the wrong time to the wrong person. Maybe he felt he got cheated in a drug deal. Those are all presumable in the circumstances, and he gets very angry and shoots him. I don't see why his reaction then would be to render aid and not run away if it's a second-degree murder versus a first-degree murder. That's the point that I'm making, is that I don't think it changes the circumstance. He probably knows he's in the wrong for having shot the man regardless of the circumstances, and running away and not trying to stay around to see whether the cops can figure out who did it. I don't think that's an indication of premeditation. I understand what the various case law said, but I think the only thing that strongly could indicate in favor of premeditation is that Mr. White was unarmed. But again, these are obviously important factual distinctions to make, but I think the totality doesn't support premeditation because there's very little information that we got from Ms. Corley at all. On top of that, you know, I don't think there's a strong indication of premeditation here. I think that the lack of information, the case law also says that, you know, in the absence of something, it is second-degree murder, and that no single factor, even if it's demonstrated, is going to be sufficient even of itself necessarily to support premeditation. So unless the court has any other questions for me, I'm going to reserve the balance of my time.
Thank you.
Good afternoon, Your Honors. May it please the court, Nick Spangler for the state of Tennessee. I'm actually, unless the court prefers otherwise, I'm going to take the issues in the reverse order that the defendant discussed them, because I think the discussion of the sufficiency of the evidence will give important context maybe to my harmless error argument on the open door issue, which is maybe where we will land and maybe should land. So we respectfully ask the court to affirm this defendant's conviction for premeditated first-degree murder because there is sufficient proof of premeditation. As the court knows, the sufficiency review standard heavily favors the jury's verdict here, which is supported by adequate circumstantial proof that the defendant premeditated this murder of Mr. White. It's more often than not that the state relies on circumstantial rather than direct evidence to establish a guilty mental state, and that's certainly what we're relying on here. And specifically, we point to 7 circumstances in this record that this court and the Tennessee Supreme Court have identified as indicative of premeditation. And the first is, we submit the proof creates a reasonable inference that this defendant prepared to conceal the murder beforehand. And what I mean by that is the jury could infer that the defendant arranged this discrete location where the murder occurred for the purpose of making it less likely that it would be detected. And so we know that this location in an alleyway was more discreet. There are photos of this alleyway in the record. It was less visible than, say, the sidewalk, the street, somebody's front yard in this residential area. And then we know that there was this verbal exchange. There's not a lot of information about this. There's some sort of short verbal exchange and then short hand-to-hand exchange. Doesn't appear to be confrontational, appears to be consensual. So that suggests that this meeting was not happenstance. These two gentlemen had prearranged to meet at this location. And then finally, because the defendant ended up being the aggressor in this situation, we submit that supports a reasonable inference that he was the one that planned that meeting location. That and the fact that he was the one waiting at that location. Ms. Corley testified that it was the victim that actually came across the street, walked past her, and then got to the defendant who was waiting in the alleyway. So we submit that all those support the rational inference that the defendant arranged this meeting spot for the purpose of concealing the murder that he committed. And then we also have the proof that shows the defendant obviously procured a murder weapon before meeting with White. He showed up ready, willing, and able to commit this murder. He had a loaded pistol in his waistband that he pulled out. And the proof also shows that White did nothing to provoke the defendant before he opened fire. Again, all we have is a brief verbal exchange, a hand-to-hand exchange, nothing confrontational from Ms. Corley's view, and then he pulls out this weapon and fires 5 shots at the defendant. And then obviously we have use of a deadly weapon, which by statutory definition is, pistols by statutory definition a deadly weapon. And then we have multiple gunshot wounds on Mr. White. So the proof we have there, I keep repeating 5 gunshots because they found 5 shell casings of the same caliber. Then we have 4 bullet wounds on the victim that the medical examiner testified were caused by 3 different bullets, which leads to the next factor, which is 2 of those 3 bullets hit the defendant from the backside, 1 on his back on the torso and 1 in his buttock, which shows that he was actually retreating at the time those 2 shots were fired, which again is indicative of premeditation. And then finally, the proof shows that the defendant rendered no aid to White after shooting him. Ms. Corley testified that he simply took off while the victim sort of stumbled across the street and fell face down before dying shortly thereafter at the hospital. So we submit that all these circumstances show that the defendant murdered White with premeditation, that is, after the exercise of reflection and judgment sufficiently free from excitement and passion. So now we'll get to the open door issue. We submit the court should also affirm the conviction because admission of this cell phone location data was well within the trial court's broad discretion under the open door doctrine, and in any event, its admission was certainly harmless. So admittedly, I think reasonable minds could probably disagree about the propriety of the trial court's decision on this open door question, but that in and of itself is the definition of abuse of discretion review, and I think it shows that the trial court was within its discretion. Even though another judge might disagree, the court was within its discretion to make that call. So the way the open door doctrine works, this is actually the first case I'd had with this issue. The way it works is it allows inadmissible evidence to come in when the subject of that evidence is raised by one party in a way that gives that party an unfair or misleading advantage. And the proportional remedy then is to admit that otherwise inadmissible evidence so as to correct the misleading advantage. And that's exactly what happened here. So we had the defendant cross-examining the lead detective, and he steered the lead detective to basically say that there was absolutely no physical evidence connecting this defendant to the crime scene. And so by doing that, he raised the subject of physical evidence, and he gained a misleading advantage around that subject by suggesting there was no other corroborating evidence. So allowing this cell phone data was a proportional remedy that was just enough to correct that misleading advantage. It showed that there was indeed some physical evidence that marginally, and I stressed marginally, corroborated that the defendant was at the scene at the time of this murder. I think that the focus on the semantics of whether it's physical or not is not particularly helpful. So cell phones are physical, cell towers are physical, cell phone signals, although not visible, are radio waves. They are physical in the physics sense. Please don't ask me to explain it any more than that, but it is physical in that sense. And you talk about other physical evidence. I mean, DNA, maybe a report comes in, maybe it doesn't, maybe it's just the testimony. So the evidence is testimony, but it still relates to physical evidence. So I don't think it's important whether we admit the cell phone or not, or admit the cell tower. The point is,
So you don't think there's a distinction between physical evidence and data?
I don't. I think the data can
case.
reflect something physical, and therefore it's physical evidence. And again, we have cell phones, we have cell phone signals, and it reflects something physical about the location of that phone relative to that cell phone tower. And again, we're under abuse of discretion review, right? So it's whether the trial court made a rational decision here under the abuse of discretion review standard. Might another judge disagree and say, hey, I don't think that's physical evidence? Sure, but under abuse of discretion, it was a reasonable interpretation of the evidence, reasonable to say that the defendant opened the door to the subject of physical evidence and allowed this marginally corroborating evidence in to correct that misleading suggestion. But I think maybe as Judge Witt would say, I don't want to tarry long on defending the merits of this open door issue because I think the evidence was surely harmless regardless. I think the court can be confident beyond a reasonable doubt that this evidence did not contribute to the jury's verdict. On one hand, we had what I think is very strong evidence, eyewitness evidence from Miss Corley, seeing the victim walk into this alleyway and get shot up by this defendant. Yes, she kind of changed her story on cross-examination, but when you read this record, she doesn't want to be there. She doesn't want to be at trial. She doesn't really want to have anything to do with this prosecution. But every time she's away from court and in a private setting, she's going to the detective, identifying this guy in a photo lineup, identifying him by name, never at the suggestion that he had anything to do with it. The detective never told her that Tevin Griffin had anything to do with it. Nonetheless, she shows up at the YMCA, says Tevin Griffin, looks at a photo lineup, says that's him, Tevin Griffin, goes to the police station later, identifies him again during a recording interview. This is Tevin Griffin. So again and again, she's identifying him. And yes, at trial, she was very tight-lipped and didn't really want to support either side, just basically didn't want to be there. But the jury is rational. They can see through this, and they realize that she knew this defendant too. They had met when she was taking out her garbage months before, and I think he was hitting on her. So she definitely recognized who he was. I think she said they were also distantly related, which is the reason that she didn't want to testify against him, both because of retaliation reasons and because they were distantly related. So on one hand, we have what I think is this very strong evidence of the defendant's guilt, and then in contrast, we have this very, very marginally corroborative proof that months later, the defendant was found with a cell phone, among many cell phones that he possessed at the time, that was registered to his father and that happened to ping on a tower that was consistent with covering the area where this murder happened. And I think it does add something to the proof. I mean, we talk all the time in ballistics evidence, right, that you can't say that the bullet came from the gun, but the rifling pattern on the bullet is consistent with being fired from that gun. So it's not conclusive. Maybe it's not something to support, beyond a reasonable doubt, but it adds something to the scale. And then we have this detective that says, every chance he repeatedly downplayed the import and reliability of this data. He says, we can't say for sure where the phone is because cell phones often don't use the closest tower. He said the phone may have been miles away from the pinging tower. And he said we can't say with any degree of assurance or certainty based on the data that the defendant was anywhere near the crime scene that day. So given the very marginal corroborative value of this evidence relative to the strength of Ms. Corley's testimony, we submit that the admission of this cell phone evidence was harmless beyond a reasonable doubt. I'm happy to answer any questions the court may have. Otherwise, we respectfully ask that you affirm. Thank you.
Your Honor, with all due respect to the opposing counsel, I don't think anybody would like to have gone into a trial and gotten the testimony they got from Ms. Corley to be the sole piece of evidence that they relied on in order to get a conviction. Just reviewing my briefly, she said in trial she didn't get a good look at the suspect. She said that she made the identification because she was tired